Well, hello everyone. I just wanted to take a minute to talk with you about one aspect of the Trump cases that I did not mention in the main video. I'd like to deal with it separately, and that is a particular defense that he has talked about, and I'm not clear on whether he's actually going to assert this. It's called the advice of counsel defense, or more fully, the good faith reliance on the advice of counsel defense. Now, this is potentially a defense that he could assert maybe in all these cases, because there, as you may have noticed from the previous video and from the list of defendants and unindicted co-conspirators, a lot of these people are attorneys. So, for example, in the New York hush money case involving the payments to Stormy Daniels and the other woman that were then concealed, the allegation is they were concealed through falsified business records, and that's kind of the charge. Remember, Michael Cohen was Donald Trump's attorney. He actually pled guilty in that case, and he did time in prison and has served a sentence and is now free. So, Trump has made various statements saying, well, I was relying on Michael Cohen's advice. Okay, in the case involving the attempt to overturn the election result, the same thing. You've seen there's a whole bunch of attorneys involved in this: John Eastman, Rudy Giuliani, and others. And Trump could conceivably claim, well, I was just, they told me that everything I did was legal, and they told me I could call the secretaries of state in these various states. They told me I could do this and that, and try to argue that he was acting on the advice of counsel. I'm going to explain the elements of this in a minute, but just how this is how it's relevant. And then, in the case involving the documents, I suppose you can make a similar argument. The government documents case, say, oh, my attorney told me it was okay. Problem there, factually, which is that these attorneys made clearly inaccurate representations to the government regarding what had been turned over. So, could be a problem, but potentially. And same thing in the Georgia case. The Georgia case, you could, make that argument just as he could in the, there we go. Just as he could in the D.C. case involving the attempt to overturn the election, he can make the same argument in Georgia. I was following the advice of counsel. Now, this is potential. Now, let me explain to you why I personally am not so sure that he's really going to actually do that when push comes to shove in court. First, here are the elements of the advice of counsel defense. First, it goes to the question of unlawful intent. So it proves, or it is intended to show, that the defendant did not have the criminal or unlawful intent that is required to convict them of a crime. So they may have done certain things where the acts themselves might arguably be illegal, but if they were not done with a criminal intent, then maybe they aren't illegal. That's the way it would go. It goes to the defendant's intent. And so it goes like this. First, here are the elements to prove that defense. You have to show, one, the defendant made full disclosure of all material facts to the attorney or attorneys in question. The defendant has to do that. They have to show they told their attorney or attorneys everything, full access to all the information. Number two, after doing that, they received the advice from an attorney regarding a specific course of conduct, how you should conduct yourself. The defendant was told by the attorney, okay, in view of everything you've told me, here is what I say you should do. It will be legal for you to do the following thing. I recommend that you do this. Words to that effect, so that the attorney is recommending a course of conduct, a position, to the defendant. And then the defendant reasonably, this is the third part, reasonably and in good faith follows the attorney's recommended course of conduct or their advice. So three things. One, the defendant has to make full disclosure of all the facts to the attorney. Two, the attorney has to make an actual recommendation that is received by the defendant regarding how they should behave. And three, the defendant has to actually have done what the attorney told them to do reasonably and in good faith. Now, those are the elements. But here's why I'm not so sure it's going to be part of these prosecutions, we shall see. And that is because something happens immediately. When you actually plead that defense, when a defendant puts that forward and says, I am asserting a reasonable reliance on the advice of counsel of defense, first thing that happens is your attorney-client privilege is waived. All communications between the client and the attorney now become open to the prosecution. They get to see, hear about your phone calls. They can put the attorney on the stand. They can put the defendant on the stand. They can see all the memos, all the emails, all the texts, everything that went on between the attorney and the client. Why? Because we're going to find out, if you're saying my attorney told me to do it, we're going to find, and I did what they told me, we get to see, the prosecution gets to see, what did the attorney tell you, and did you really do it, and did you really disclose all the facts, or did you withhold things, or give them false information, etc. So one reason why people often say they're going to assert this privilege, but often they don't. Why? Because everything that went on between them and their attorney becomes basically public information. It goes over to the prosecution to review, to introduce as evidence in a trial, which usually means you can't use that attorney in your case. That attorney who gave you the advice becomes a witness, and you have to have a different attorney or attorneys to represent you in the case, because they're going to be calling as witnesses the attorneys who you say gave you the advice. Now, the other problem here is this. The three elements can be poked at and prodded at, and that's why the defense often does not work as a practice. It is rarely actually put forward, and often it just doesn't work. And the reason it doesn't work is because either maybe the client did not give all the facts to the attorney, maybe often what the attorney told the client to do is not exactly what the client did. And it has to be consistent. You have to have followed the advice of the attorney. If you went beyond it, that's a different story. Then you can't say, if you did anything in this whole process that the attorney did not advise you to do or told you shouldn't do, then you lose. That defense doesn't work. And the other thing is this whole reasonably and in good faith. You have to be, as the client, you have to reasonably and in good faith act on the advice. That means both you and the attorney have to think reasonably and in good faith that what you are doing is actually legal. And if there are any communications, now that remember it's all been exposed, if there's any communications between the attorney and client where they're saying, boy, I'm not so sure this is legal, or maybe this way we can fool the police, or we can fool the tax collectors, or we can fool whatever. If there's anything in those communications that casts doubt on whether you are acting in good faith, did you both really believe this, that it was legal? If any of that shows that you didn't have that good faith belief, the defense fails. See? It doesn't work. Because both the lawyer and the client have to be reasonably believing that they're acting in good faith on this. Now, so for example, in the case of the attempt to put together these slates of false electors, fake electors, and one of the plots that is alleged by the Jack Smith in the insurrection, that's the insurrection case, but the overturning the election case. Trump has not been charged with the insurrection, so pardon me. But Kenneth Chesbrough, who is one of the attorneys involved, and also John Eastman, who is another attorney who gave Trump advice on this, if you look at some of the things that have already become public, some of the things that they said that became public, because some of it did become public, memos that weren't literally attorney-client communications, some of this has already come out. You can see that they had doubts about their own legal strategies. They actually had doubts themselves that about whether or not what they were saying was legal. And see, that goes to the reasonably and in good faith part. So we'll just have to see if Trump does really go forward with these defenses, but he might. I mean, it's possible. He has made public statements to that effect, but as you can see, as we go through the elements, it takes more than just talking. I mean, if you do this, you're waiving your attorney-client privilege, and everything is going to be exposed that went on between you and the attorney, and the prosecutors will try to show that you did not act reasonably in good faith, or that you did not fully inform the attorney, or that you did not do exactly what the attorney told you to do. So we shall see, but I wanted you to know that is a defense that could potentially be put forward, maybe even in all of the cases, or some of them, that Trump is now facing. So there's another bit of food for thought for you for this week. So thanks a lot, and I'll talk to you soon.